Okay, so we now proceed with the rules of procedure for environmental cases. So this is AM number 09-6-8-SC. SC stands for Supreme Court. Okay, so what is the title of the rules? Dinagnan. Okay, so the rules shall be known as the rules of procedure for environmental cases. Bakit hindi siya nag-select sa screen? Ayan. So when did the rules take effect? So it took effect last April 29, 2010. Okay. So what is the scope of the rules? The rules govern the procedure in civil, criminal, and special civil actions before the regional trial courts, metropolitan trial courts, municipal trial courts in cities, municipal trial courts, and municipal circuit trial courts involving enforcement or violations of environmental and other related laws, rules, and regulations. So basically, sa mga courts na ito, doon dinirinig yung mga kaso involving environmental crimes. So kasama dito ang mga ito. So hindi ko na isa-isahin. Sesend ko na lang din itong lecture sa inyo. Okay, pero itong mga nakalagay dito ay yung lahat ng mga batas pertaining to environmental laws. So what are the objective of the rules? So first is to protect and advance the right of people to health and balanced ecology. And letter B, to simplify and make procedure inexpensive for the implementation of precautionary principles to ensure just and equitable administration of remedies and redress of violation of environmental laws and to enable courts to manage and monitor environmental cases. So what are the salient features of the rules? First is to have a liberalized standing. And any real party in interest, including the government and juridical entities authorized by law, may file a civil action involving the enforcement and violation of environmental law. So anyone could file a case involving a violation of an environmental law. Any Filipino citizen in representation of others, including minors or generations yet unborn, may file an action to enforce rights and obligations under environmental law. Especially, di ba, we try to preserve the present environment that we have. This is not only to benefit tayong mga nabubuhay at present, but it is also for the benefit of the generation, sabi nga dyan, yet unborn. Kasi kung ngayon pa lang hindi na natin mapapalagaan yung environment, anong aabutan ng sunod na generation, di ba? Kaya we could also represent the generations yet unborn. Okay. Another salient feature of the rules is that proceedings are summary in nature. So both complaint and answer must include affidavits of witnesses and material evidence. Then, rules allow the application of precautionary principle. Said principle states that in cases where human activities may lead to threats of serious and irreversible damage to the environment that is scientifically plausible but uncertain, precautionary principle shall be applied. Kumbaga, kung kaya nang maiwasan, iiwasan na. Yun yung precautionary principle. In such cases, actions shall be taken to avoid or diminish that threat. Because when dealing with environmental laws, hindi siya madaling magawan ng paraan. Hindi siya madaling i-repair. Hindi katulad, for example, nabangga yung sasakyan mo. Kumbaga, dalhin mo lang sa kasa, dalhin mo sa talyer, maaayos na siya. Matagal na yung 2 linggo. O matagal na kamo isang buwan. Pero definitely hindi yan naabot ng kalahating taon, ng isang taon o higit pa. But in damage to the environment, it would take years, decades even, baka pa century, 'di ba? Kaya hindi siya kumbaga kaya matindi yung pangangalaga sa environment kasi hindi siya madaling ayusin kapag nasira na siya. Okay. So what are the novel provisions of the rules? Availability of environmental protection order. Parang familiar naman siguro kayo dun sa anti-vowsy law, 'di ba? May barangay protection order, temporary protection order, permanent protection order. So may ganun din sa environment, environmental protection order. So an EPO is an order issued by the court directing or enjoining a person or government agency to perform or desist from performing an act in order to protect, preserve, or rehabilitate the environment. Pwedeng mag-enforce siya or pwedeng magpigil siya ng isang act. This is effective for 72 hours from notice to the party enjoined. Summary hearing shall be conducted afterwards. It may be lifted anytime by the issuing court. No bond is required from the applicant. And then prohibition against temporary restraining order and preliminary injunction. So the rules provide that except the Supreme Court, no court can issue a TRO or writ of preliminary injunction against lawful actions of government agencies that enforce environmental laws. And then recognition of rules of the concerned government agency on the custody and disposition of seized items, equipment, paraphernalia, conveyances, and instruments, and requirement of consent by concerned government agencies in case of plea bargaining. Another is the provision on strategic legal action against public participation. And then the availability of writ of kalikasan. The writ is a remedy available to a natural or juridical person on behalf of persons whose constitutional right to a balanced and healthful ecology is violated or threatened with violation by an unlawful act or omission of a public official or employee or private individual or entity involving environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in two or more cities or provinces. Kapag gano'n na kalawak yung maapektuhan, two or more cities or provinces, di ba? A writ of kalikasan may be asked para hindi madamage yung environment because uh, it would violate yun nga yung mga constitutional right ng mga taong involved o mga taong nandoon sa cities or provinces na yun. Then we have the writ of continuing mandamus. Continuing mandamus is a writ issued by a court in an environmental case directing any agency or instrumentality of the government or officer thereof to perform an act or series of acts decreed by final judgment which shall remain effective until judgment is fully satisfied. Okay? Yung nabanggit kanina, yung SLAPP, Strategic Lawsuit Against Public Participation. So this refers to an action, whether civil, criminal, or administrative, brought against any person, institution, or any government agency or local government unit or its officials and employees with with the intent to harass, vex, exert undue pressure, or stifle any legal recourse that such person, institution, or government agency has taken or may take in the enforcement of environmental laws, protection of the environment, or assertion of environmental rights. Yan ang strategic lawsuit against public participation. Then yung nabanggit kanina, yung writ of kalikasan, uh, Ayan. The underlying emphasis in the writ of kalikasan is magnitude as it deals with damage that transcends political and territorial boundaries. Kasi nga, katulad ng nabanggit natin kanina, two or more cities or provinces na ang involved. Tapos, um, malaking damage nga ang magagawa nito sa kanyang, doon sa mga inhabitants, doon sa cities or provinces. So, acts covered by the writ. The WOC is a special remedy. Yung writ of kalikasan is a special remedy available against an unlawful act or omission of a public official or employee or private individual or entity involving environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in two or more cities or provinces. So, ano ang difference ng writ of continuing mandamus and writ of kalikasan? Sa continuing mandamus, it is directed against the unlawful neglect in the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station in connection with the enforcement or violation of an environmental law, rule, or regulation, or a right therein, or the unlawful exclusion of another from the use or enjoyment of such right, and in both instances there is no other plain, speedy, and adequate remedy in the ordinary course of law. In writ of kalikasan, on the other hand, it is available against unlawful act or omission of a public official or employee or private individual or entity involving environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in two or more cities or provinces. In addition, magnitude of environmental damage is a condition sine qua non in a petition for the issuance of a writ of kalikasan and must be contained in the verified petition. Okay? Sa continuing mandamus, may pagpapabaya sa pagpapatupad ng batas. Sabi nga dyan, no? Unlawful neglect in the performance of an act which the law specifically enjoins as a duty. Kailangan daw yung batas ipinapatupad. Pero kapag yung batas hindi na ipatupad, yun ang ano mo, i-file yung writ of continuing mandamus. On the other hand, writ of kalikasan, kapag may gumawa ng krimen, may gumawa ng environmental crime, whether public official or employee niya or private individual, na kung saan nga malaki ang damage nito sa environment. Yun naman ang writ of kalikasan. Okay, another comparison. Sa writ of Sa writ of mandamus, ang pwedeng mag-file, a writ of continuing mandamus is available to a broad range of persons such as natural or juridical person, entity authorized by law, people's organization, NGO, or any public interest group accredited by or registered with any government agency on behalf of persons whose right to a balanced and healthful ecology is violated or threatened to be violated. So sila, halos lahat. Ang dami. Ang daming pwedeng mag-file ng writ of continuing mandamus. On the other hand, sa writ of kalikasan, the petition for the issuance of a writ of kalikasan can be filed by any of the following: a natural or juridical person, entity authorized by law, people's organization, non-government organization, or any public interest group accredited or registered with any government agency, almost the same lang, sa continuing mandamus, on behalf of persons whose constitutional right to a balanced and healthful ecology is violated, involving environmental damage of such magnitude as to prejudice life, health, or property of inhabitants in two or more cities or provinces. Those who may file for this remedy must represent the inhabitants prejudiced by the environmental damage subject of the writ. The requirement of accreditation of a group or organization is for the purpose of verifying its existence. Kasi baka naman, non-existent yung organization na yon, baka paper company lang yon. Tapos sinasabi nila sila yung representative. Eh, may ibang balak yun. Pag ganun, di ba? Scam yun. So the accreditation is a mechanism to prevent fly-by-night groups from abusing the writ. Ayun. So sino naman ang respondent sa mga writ na ito? The respondent in a petition for continuing mandamus is only the government or its officers. On the other hand, sa writ of kalikasan, the respondent may be a private individual or entity. And it may also be government officials. Okay? Exemption from docket fees. Sa writ of continuing mandamus, exempted from the payment of docket fees. Writ of kalikasan, same lang din. Exempted sila. Pinaghiwalay lang, pero parehas lang. Venue. Saan dinirinig yung kaso? In writ of continuing mandamus, a petition for the issuance of a writ of continuing mandamus may be filed in the following: the RTC exercising jurisdiction over the territory where the actionable neglect or omission occurred, or the Court of Appeals, or the Supreme Court. And then sa writ of kalikasan, given the magnitude of the damage, the application for the issuance of a writ of kalikasan can only be filed with the Supreme Court or any station of the Court of Appeals. Hindi katulad sa continuing mandamus, involved pa ang RTC. Discovery measures. The rule on the writ of continuing mandamus does not contain any provision for discovery measures. On the other hand, the writ of kalikasan incorporates the procedural environmental right of access to information through the use of discovery measures such as ocular inspection order and production order. Damages for personal injury. So the writ of continuing mandamus allows damages for the malicious neglect of the performance of the legal duty of the respondent. Kasi nga, sa continuing mandamus, may pagpapabaya sa part ng government agency or government official na ipatupad yung batas. In the writ of kalikasan, no damages may be awarded in a petition for the issuance of a writ of kalikasan consistent with the public interest character of the petition. Yun na nga, walang damages na ibibigay sa petitioner dahil public interest. A party who avails of this petition but who also wishes to be indemnified for injuries suffered may file another suit for the recovery of damages. So separate na action yun. It's not part of filing for a writ of kalikasan. Since the rule on writ of kalikasan allows for the institution of separate actions. Okay. Next is the criminal procedure. Okay. Criminal procedure. First is prosecution of offenses. So how is a criminal action for violation of an environmental law instituted? So it is instituted by filing a complaint with the Office of the Prosecutor of the place where the crime is committed. Of course, dahil, well, basic naman ito eh. Kung saan ang jurisdiction, di ba? Doon ka magpa-file. Sino ang nakasasakop doon sa lugar kung saan nangyari yung krimen, doon mo ipa-file yung kaso. So, ayun. Office of the Prosecutor. So, ano daw ba ang complaint? Specifically pertaining to environmental laws. A complaint is a sworn written statement in question and answer form, charging a person with an offense, subscribed by the offended party, any piece or other public officer charged with the enforcement of the environmental law violated. Who may file a complaint? Any offended party, peace officer, or any public officer charged with the enforcement of an environmental law can file a complaint. So, examples, the protected area superintendents for violation of NIPAS Act inside their respective protected areas. Yung NIPAS, nabanggit yon dun sa pinanood yung lecture kanina. And then DENR, Community Environment and Natural Resource Officers sa CENRO, Provincial Environment and Natural Resource Officers of PENRO, and Deputized Environment and Natural Resource Officers for violation of forestry laws and other environmental laws. And then number 3, Wildlife Enforcement Officers for violation of the Wildlife Resources Conservation and Protection Act. Can police officers and other law enforcement agents file a complaint for violation of environmental laws? Yes, because they are included in the term any peace officer. Alam niyo naman yon, ang police officers are peace officers. Then can police officers directly file the complaints without involving other government agencies such as the DENR or the BIFAR? Yes. DENR stands for Department of Environment and Natural Resources. BIFAR is Bureau of Fisheries. Okay? And then, ayun nga, the answer is yes, they can file the case directly if technical consideration is not necessary to determine probable cause. However, in cases where technical certifications are necessary, then the corresponding agency must be involved for the case to prosper. Okay? So yun lang ang kailangan. Yun lang ang consideration. Kung may technical consideration, hindi pwedeng didirekta ang pulis. Kailangan pupunta muna sila sa tamang agency para makakuha ng technical certification. But kung wala namang technical consideration, pwede nang direkta yung pulis na mag-file. Okay? Ay, gumalaw. Okay. So what are the examples of cases where technical certifications are needed? Examples of blast fishing and cyanide fishing cases where fish examiners from the lead agency need to certify that the fish were caught with the use of explosives and cyanide, respectively. So, ayun na nga, kailangan, kumbaga, may autopsy pa yung mga sa ganitong cases, sa mga isda, titignan muna kung talaga bang ang kinamatay nung isda ay because of the use of explosives and cyanide. So another example is pollution cases where technical determination of the kind of pollutant and pollution levels is needed. So yun. Pag mga ganyan, hindi naman yan masasagot ng pulis. At hindi naman kasi expert ang pulis sa mga ganito. We have separate experts for this. Kaya kailangan ng technical certifications nung experts na yun bago makapag-file ng case yung pulis. So what are the examples where technical determinations by environmental agency is not required? Yung mga pagkakataon na pwede ng direct na pulis na ang gagawa. So example is the possession of dynamite, where the technical determination of the presence of explosives is determined not by the environmental agency but by the PNP or NBI crime laboratory. So yun. Yun, may hawak ka lang na bomba. Can a complaint be filed directly with the court? Ito, kahit hindi ko na-explain, alam niyo na to. Wala namang case na direkta sa court, di ba? Lahat dumadaan muna sa prosecutor. CJS niya yan. So the answer is no, obviously. A complaint for violation of environmental law can no longer be filed directly with the court. It can only be filed with the concerned office of the prosecutor. Only an information charging a person with a violation of an environmental law and subscribed by the prosecutor can be filed with the court. Kapag may information na. And then what accompanies the complaint when filed with the office of the prosecutor? First is the mission order, kung meron. Sworn statements in question and answer form of the arresting officers and witnesses. Then we have pictures, logically showing the scene of the crime, the object of the offense, such as illegal logs, wildlife, hazardous waste, or toxic substances, conveyance, tools, and other paraphernalia used in the commission of the crime. So if pictures are submitted, this must be accompanied by sworn statements in question and answer form. In question and answer form of the person who took the photographs, by persons who were present when said pictures were taken, or by any competent persons who can testify on the accuracy of the pictures. And then we have the seizure receipt, inventory or tally sheet of the items seized, turnover receipts, if any, to show the chain of custody of evidence, and then endorsement letters kung meron din, turning over the case from arresting officers to the police investigators. Certifications from DENR, DA, BIFAR, or other concerned government regulatory offices on the issuance of the permits or the authenticity of the permits, if any, were shown by the violators, and referral slip addressed to the concerned office of the prosecutor. Can government agencies be stopped from lawfully enforcing environmental laws? Pwede daw bang hindi ipatupad ng government agencies yung mga pinatutupad nilang environmental laws? So, except the Supreme Court, no court can issue a TRO or writ of preliminary injunction against lawful actions of government agencies that enforce environmental laws. So, who is in charge of prosecuting environmental cases? Yung public prosecutor. Can private lawyers help in the prosecution of environmental cases even if there is no private offended party? Pwede bang makialam? Pwede bang tumulong yung mga private lawyers? Yes. In criminal cases where there is no private offended party, a counsel whose services are offered by any person or organization may be allowed by the court to appear as special prosecutor. Pwede naman. With the consent of and subject to the control and supervision of the public prosecutor. So, napag-aralan nyo na rin to sa CJS ninyo and sa procedure ninyo. Pwede naman din sila ma-involve, pero meron pa ring public prosecutor na magsusupervise sa kanila. Okay.